have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to Viewer Discussion. I'm your host, Joe Neerman, a.k.a. Good Lawgic. Hope that your Sunday been going well. Hope everything's been going good for you. I don't really have a lot to share with you all other than one thing, and that is that I'm close to coming to terms with like a certain streaming service where I'd be live streaming to that platform. It's not the T's are not yet crossed, I's are not yet dotted, but if this happens, it'll likely happen fairly soon. It will not cost any of you a penny to partake in my content there. There's absolutely no fee associated to me or the platform or to anyone. But I'm likely going to be working with them in the very near future, perhaps even producing content this week. I will keep you better informed on that on Locals, where I provide links to anywhere I am on social media, anywhere at any time, and that is at goodlogic.locals.com. So if you're interested in making sure that you follow my content, I recommend sign up at goodlogic.locals.com. Even if you're not a paying member there, even if you don't join anything, you don't become an official digger, whatever it is, even if you don't do that, at the very least, you'll have notifications as to where you can find my content and work that I'm producing. And that will probably be a whole mess of daytime streams that I'll be producing over the next month or so. So I just want to give you a heads up about that so that those of you who are interested in keeping tabs on work that I put out there on social media, that you have knowledge of forethought on that. But that notifications about that, you're not going to find everything I do on social media unless you're like, a very only the most dedicated fans are going to find everything I do on social media. I'm not anticipating that any individual would keep track of everything I'm doing on social media. But for those of you who want to try and fit me into their schedule, that might actually work out better for some of you if I'm streaming during the day. And like I said, any appearances I make there will be completely free to you. It's just content that I'm producing on social media, and I'll keep you updated on that. The first place I'll notify people about that, once it becomes official, will be on Locals. So that's goodlogic.locals.com. And anyone who signs up there gets free notices about anywhere that I am, as well as other content that's produced from time to time. That seems appropriate. Without further ado, I want to get back into Fani. Yesterday, we were watching the work of Adam Abbate. Adam Abbate, the struggling young man, the struggling young lawyer from the district attorney's office, who's desperately trying to convince the judge as to what it is, as to why it is. He's just ignore your lying eyes and just recognize you need to keep Fani in on this case. You have to keep her. You got to keep her in. Let's check out what his thought process is on that. We were roughly an hour and 13 minutes in. I actually went back a few minutes because I thought the last argument that he made right before I wrapped up was an interesting one. So for those of you who missed it, didn't make it all the way through 3 hours of my content last night, I understand that, and I'm going to try and catch you up to date on that and hopefully provide additional insight as well. So without further ado, let's get back into it.
And the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides.
This is where he skipped through a whole series of law after the judge was basically not having it. And just to remind you, this is something I was touching on, I think mostly during the last half hour of my stream from last night. I'm doing part one of this. Is that there's really two different areas where you can look at as to how much evidence needs to be before this judge before he has an option of kicking her out, how much evidence needs to be in front of him before he's required to remove her. And those are different, potentially different yardsticks. It could be that there's a leeway period there where if he feels a certain way about something, in that case, he can go along with removing her if he thinks that that's in the best interest of upkeeping jurisprudence and reputation of the court. It seems like there's probably this gray area in there where no matter which way he decides, the law probably would support it. And again, I want to just point something out to you here. There's a few things I need to point out to you. I've talked a lot over the last several months about the fact that when you are dealing with new areas of law or areas of law that are infrequently tested, a large part of what becomes the law comes from a judge making a decision that never gets fully challenged, or even if it's challenged, the overlord courts don't feel strong enough about it to clamp down and say you were wrong. So it sort of becomes an established pattern and practice. And it's an interesting thing that, one of the things Adam Abbate was trying to say is that, and he closes, and we're going to see tonight that he closes and finishes with courts traditionally are very hesitant to actually remove a prosecutor. And perhaps that, and I'm sure that's true. We don't hear very often about prosecutors in their offices being removed from a case. And perhaps that's a little bit of a reflection of this. One of the things I was trying to point out, and I've talked about this in the context of Trump cases in general, is that when you don't have areas that are frequently examined, there's just sort of an understanding of what the law is. That doesn't necessarily make that the law. And sometimes just there's an established practice that this is what is considered normal and natural, and that sort of almost becomes the law once it's going on for a long period of time. We can look at this in the context of immunity that now is before the Supreme Court, presidential immunity for acts within the scope of his office. That there is no law on this because there's never been any prosecution, never been an attempt to prosecute. There's sort of been an understanding that the way we read the Constitution is the way that Trump and his team want the Supreme Court to read it, which is that you need to have an impeachment prior to there being some sort of criminal prosecution. And there's a lot of logic to that. Don't get me wrong. If you ask me, that's how I would read it. That's how I understand it. But technically, it's not there in black and white saying he is immune. There's an implication, a negative implication from the fact that it says this is a situation where you can be convicted. Does that mean that that's the only situation you can be convicted? According to the D.C. Circuit Court, whose logic I think is wholly unfounded and kind of stupid, but that still was their argument, was that's not the only scenario. That's one scenario where he could be facing criminal charges, but that there theoretically could be other scenarios where a president could be facing criminal charges for acts within that seem to be within the orbit of what he's supposed to do. And the point that I was making when I was talking about this back then, and that applies here too, that's why I'm bringing it up now, it applies here too, is that if something doesn't really come up, it's almost like when you live in the Wild West, when you're first establishing law and order in a new frontier. So who is in charge? Who makes decisions? Who's allowed to just claim a piece of land? What makes land yours? All these different things. What makes for something that's considered moral and ethical is really determined by the people who are there and just sort of planting their flag. And if it goes unchallenged, that just becomes established and accepted norm. I tried giving this example back when I was first introducing this to say, to just sort of looking at the nature of relationships with like establishing boundaries in a friendship. When you meet someone new, the level of friendship that you have with them, is that someone who you can call up and ask a favor for? Is that someone you can call up without texting them first? These are all boundaries that society on a micro level try working out between each other as to what is appropriate. In the social dating world, at what point is it too fast to call a girl? These are all things that people and society starts setting up, but it's only once people start doing it, and then people aren't freaking out about it, people aren't reacting harshly to it, that it becomes established as being patterns that are tolerable. And these may change over time. We saw that the way women were treated in the workplace. If you look back how women were treated in the workplace 75 years ago, that would be considered by almost anyone today to be something that people would look at the way most men treated most women in the workplace 75 years ago as being as being, somewhat sexist. By today's standards, it is. By today's standards, it would be deemed sexist. And the point is that what is considered okay and what's not considered okay, A, can shift through time. B, is really established by people just deciding things and then no one really freaking out that they're just deciding they're going to do X, Y, Z. And then everyone just sort of being like, oh, okay. Oh, okay. And that sort of establishes what the law is. We're in the same terrain over here because a prosecutor being removed from a case doesn't really come up that often. There are boundaries as far as where she must be removed, or he, if he's a male prosecutor, must be removed. Because if there's a conflict of interest and there's established in the law, this is what happens, well, in that case, that must be removed. When you start getting into very gray areas where you're talking about an appearance of impropriety, that starts to feel very, very case-by-case oriented, very subjective as to like what is an appearance of impropriety. And yet, all the case law, at least in Georgia, seems to imply that appearance of impropriety is enough. But even when we talk about what's an appearance of impropriety, how sure must you be that there's an appearance of impropriety? How much evidence do you have to have? Is it beyond the preponderance of evidence, or is it clear and convincing evidence? Or is it beyond a reasonable doubt? That, okay, it's, for example, I'll ask you right now, in this case, okay, how positive, before there was geofencing information, before the phone records, how positive were most people that they were having an ongoing romantic relationship before that preceded November 1? The standard of proof that we had probably passed to most people preponderance of evidence. Is it beyond a reasonable doubt that everyone's like, definitely for sure they were? Probably not. But then once you get to a state, once you get that fence, the geofencing location, we see hardcore, tangible evidence showing that, look, these people were hanging out 4 o'clock in the morning on September 29th, September 30th, early in the morning, and that he's over in her house and going back and forth there. I mean, so now we're getting the level of evidence that there's this relationship that's happening there. How sure are you that this relationship is there? It goes from from that most people to being beyond preponderance of evidence, assuming this is admissible and gets in, to almost everyone. It goes from being 70% of society thinking beyond that it's more than 50-50 to being 90% of people getting beyond 50-50, maybe 95. And as far as beyond a reasonable doubt, they're probably now, they would climb up that all the people would say, no, it's beyond reasonable doubt. These two are having a romantic relationship. That probably goes, up to like at least, 30 or 50, 60% of people now thinking it's beyond reasonable doubt. Once that's because there's more evidence that's showing that there's this relationship there. Now, does that necessarily mean a conflict of interest? Okay, now we know there's a relationship. Does that mean that there's definitely a conflict of interest here? That's a little murkier. So when the judge has to wrap his head around all of this as to like, what does that show me? Is that appearance of impropriety? Is that a conflict of interest? How much evidence do I have with the phone records, without the phone records? How positive I am? What am I supposed to do with this Bradley testimony? And when am I supposed to believe him? When am I not supposed to believe him? And is there such a thing as saying, look, my gut tells me that this guy looks like that he has his thumbs, that off camera, someone's got his thumbs in a vice and they keep turning it every time a question is thrown in front of him? I mean, so now I should believe him about the text messages. So what ends up coming out for the judges, I'm only believing him when he's not under oath and he's speaking in private. That's when I'll believe him. But when he's actually under oath, when we expect more credibility, that's where I'm not going to believe him at all, which is a weird place for a judge to be. It's a very weird place for a judge to be. Now, we understand why we would get there, because they seem really freaking corrupt and they seem like they really twisted the screws on him. But that's why I'm saying that there's a lot of murky area here. And since it's so murky and we're in the frontier land, right, where it's like the rules and boundaries, there's some hardcore rules, some hard and fast that you can't get to, if we're positive that it's beyond reasonable doubt that there's a conflict of interest here, everyone says get rid of them. But let's say we don't reach quite that's a conflict of interest. Let's say we just reach to, beyond reasonable doubt that there's impropriety, the appearance of impropriety here. Does that mean he must remove him? According to the state Adam Abbate would say no. The judge certainly seems to think yes, based on the way they had their exchange back and forth. That if there's an appearance of impropriety, even though Adam Abbate is trying to interpret case law to say no, that all the cases where someone was removed, that there was not just an appearance of impropriety, but there was actual conflict of interest. So the judge seems to be like, come on. And that's why it was at this juncture that I just played here that he's like, I'm going to move past this case law because you don't like it. You don't like it. It's not working. It's not working. But that's why you can understand that the judge is in a very weird position here, because you have the question as far as how is it appearance of impropriety or is it conflict of interest, which seems like the judge is at appearance of impropriety. That's not conflict of interest. Now it's a matter of how strong does the evidence have to be. There has to be evidence that I think makes me more likely than not. That preponderance standards of 51%. Does it be clear and convincing, which is below reasonable doubt? It's like that's like I'm 75% sure about this. Or does it have to be 95% sure? Now, and even once I get to this, once I get that to that level, what remedies are there? If I remove Wade, which yesterday I analogized, and I think it was a great analogy that I came up with off the cuff, which was that when you have a problem of a stench, that you have this rotting meat in a refrigerator, and I have to fix this problem, does that mean that I need to remove just the rotting meat, or the people who that taint has passed to? In this context, if he removes Wade from the equation, there seems to be much less conflict of interest or even appearance of impropriety that Fani Willis herself is holding. Much, much less conflict of interest. And perhaps removing, and so in this context, and the question is, does the stench of that rotting meat pass into Fani? Is Fani now imbued with the stench of the rotting meat that is Nathan Wade? And he dropped a whole load of rotting meat into Fani's domain there, a whole load of rotting meat. And the question is if we look at her as the refrigerator here, is she now considered sufficiently cleansed by removing the meat, or is she beyond cleansing? And then potentially, even if we remove him and her, perhaps you don't have to move the entire office. The defense made a really compelling argument that she carried her taint, that she was tainted by her relationship with Wade, and she tried so desperately to cover it up that she tainted her whole office, that they're all tainted. They all have the stench of Wade on them. The stench of that rotting meat is all over, not just Fani Willis, but the stench of Wade has gone well beyond Fani and now has just filled up the entire district attorney's office, that all of them have to be removed. And that's what the judge has to decide. Does he accept that or not? Let me get to chats before I get into this. New member, Bebop and Rocksteady. I'm going to go jump to the members first. Welcome to the following. Those of you who sign up as part of this channel, you become followers. This is the following program. You become members in the following. The following is about community, unity, greater personal growth. I am not the leader of the following. I'm a follower just like you. A lot of people make that mistake. I'm not the leader of the following. I am a follower, not the leader. Not the leader. And obviously, the following is not at all a cult type of cult. Lots of evidence that the following is not a cult type of cult. No spaceships, no tracksuits, no mandatory, at least no mandatory tracksuits, mild farming, no self-harm, no harming others, no squirrel mutilations, no goat sacrifices, no throwing blood on the walls, no virgin sacrifices, no stabbing yourself with the jabby jab. There's really, it's not because why? Because it's not at all a cult type of cult. And similar, same question as Marianne or Ginger, anybody's guess. I like that. I like that analogy. Proud to be a follower. Damn Skippy. Thank you. Welcome for 3 months. 3 months of following. And speaking of followers, Debbie, gifting out the memberships. God bless you, Debbie. Let's do a quick check as to who became followers. I need to know. People got to know who has become a follower. I need to know. Let me call them out. I need to know. Where are you here? So, what I see here, Brad gifted membership by Debbie, Robert Pennington, Cedar Rose, Cena Rose gifted a membership. Nice. Daniel also old school. Daniel is one of my OG here. I remember that flag from Daniel. And Brendan Carter, all of you. Oh, big thank you to Daniel. So God bless you, Debbie. You're awesome. Thank you so very much for those memberships. We need more members in the following. The following needs a lot more members because we need a greater community. We need stronger unity. And I think society is better off when there's more personal growth. So God bless you. Last of the Yahoo says, had 2 fun conversations today. First at the range to watch the Rittenhouse trial to see what prosecutors will do. Then my mother on how lighting Bradley on fire may have sunk big wide tunnel Willis. Thanks for what you do. That's awesome. That's great. That's great. That's wonderful. All right. Worcestershire. Mini advert that preceded you was called to prayer. They're on Nice. Nice. Please tell me it's not a GoPro offer that's going around and is a scam. I don't know what GoPro offer you're talking about. I'm not sure. Oh, no, it's not GoPro. No, we were talking about when I was saying I was going to be doing some appearances. No, it's not nothing to do with GoPro. Phil Holloway, Georgia lawyer, got text message to Megyn Kelly, told Viva apparently Fani ripped Abbate to shreds after this on Friday. Nice. That's awesome. And you know what? I guess she's putting up a brave front. She was supposedly telling people that, hey, we got this. But I think they're in trouble. Question, how much of an influence in the judge's verdict does an attorney's performance have in closing arguments? If McAfee sides with the state, does that give credence to Abbate's argumentation? I don't think so. I don't know. It's hard. It's really hard to know. I guess when you're reading the one way to know is when you're reading their decision, when they write out a decision, so you sort of might see parallels to what the attorney said that might be indicative of it, different callbacks to what they said. So it's usually really hard to tell. A lot of times you would think that much like a jury sort of has made the decision before closing arguments, so to a judge would likely have made the decision. Perhaps if you introduce novel law, that could be something that would be indicative of the fact that you had an influence. It's really hard to know. If anything, it's funny. I think it's more of an opportunity for us to glean from the judge, especially when they ask questions, the way McAfee did. It gives us an opportunity to glean from the judge as to where their head is at, more than necessarily them influencing the judge. But I think there's got to be sometimes that the argument holds sway. It's really hard to tell. I'm sure it varies so significantly from one case to another that it's very speculative whether this is the case that it matters, that it's really going to have a big difference. So how do you even have a standard of evidence for looks like impropriety, not impropriety itself, just the appearance? That's what I'm saying. This is a very hard thing to know. It's a really hard thing to know. I mean, I think that you could sort of understand there's a lot of areas in law where we're sort of like there's a smell test that sort of applies where, and those are the areas whenever there's a smell test that there's much greater recognition of there being a strong deferment to judges' discretion. In areas where there's sort of like a smell test, that is where the law will tend to afford far greater recognition of whatever it is the judge decided, because they recognize that how it was said, what was said, how it was said is something that if you're there, you're going to have a better grip on it than a brilliant legal mind, right? And you can understand this if you think back to historic great legal minds of all time, right? The most brilliant philosopher on earth. And now we're sitting here, that philosopher who wasn't in the room when someone testifies has no way of knowing how that if they seemed incredibly brilliant and genuine on the stand, or if they seemed to lack any genuineness the way Amber Heard or Bradley sounded, right? So that's why your intellect doesn't really play as much of a role. your education doesn't play as much of a role as being able to watch a person and say, okay, this is something I really believe versus this is something I don't believe. So I saw someone make a comparison of Bradley to Frankie Pantagelli, and I thought that was hilarious. That was hilarious. From The Godfather. Oh, that was such a. If you saw a clip of it, I think it was in Local. Someone made a comparison. I was like, where you see Frankie just completely change his testimony, given when he looks back in the courtroom and sees Michael Corleone sitting next to his brother, and his brother's brought from the old country, and he sees Michael sitting next to him, and all of a sudden he just disavows everything he had said beforehand, and comparing Terrence Bradley. It's a great scene. Doesn't a prosecutor's extra duty to be as pure as Caesar's wife effectively lower the bar on preponderance of evidence? It wouldn't be on preponderance of evidence. See, this is where a lot of people get confused. It wouldn't be on the preponderance of evidence standard. It should lower the bar as to how much of a smell should make it bad, right? And I want you to. I'm going to keep. And you're making a mistake. You know, I believe the way you're wording this at least would lead someone who reads this to draw an improper conclusion, even if it wasn't worded, even if I'm not understanding it correctly. There's two different things. There's the appearance of impropriety, which when she reaches a certain, and there's conflict of interest, and then if it's not quite a conflict of interest, but there's an appearance of impropriety, and there are different levels of appearance of impropriety, right? How bad of an appearance is this? How bad does it look to the public? Let's say there's let's say we there's an appearance of impropriety if she got paid $200 for something that she shouldn't have gotten. How bad of an appearance of impropriety is that, though? That's another element to like this whole thing, which is a little bit murky. Like, how much impropriety is there that just people are like, oh my God, it shocks the conscience. So, but that's very different from how much evidence there is, which is the preponderance of evidence standard versus clear and convincing versus whatever. So when you're saying that the duty is to be as pure as Caesar's wife, to me, the proper scale to look at would not be how much evidence we have, but it would be how much impropriety we have, and that we should be stricter on a prosecutor, that there should be no impropriety. To me, that would... I mean, maybe you think that should also affect the burden of proof scale, but to me, it's more of like, no, there should be no stench here. You're supposed to be the good guys. You can only be the good guys going after the bad guys if you don't have this stench of impropriety. And if you're not the good guys, then why the hell should you have the authority to throw someone in prison, right? The reason we as a society give this power to prosecutors is because they're supposed to be the good guys. So I would agree with you. To my mind, to my thinking, a prosecutor is vested with the ability and power, the unique ability and power to lock people away or even have them executed, to see that justice will be implemented. They have that unique power that we as the public give that confidence to them. And because of that, because we give that power to them, they have to be beyond, their conduct should be beyond reproach, which is why it's so offensive when we see how frequently that is there. We see examples that are exactly the opposite of conduct from the DA's office that is beyond reproach. How frequently they seem to just be very reproachful, like really just completely gross and disgusting, whether it's Binger trampling on Rittenhouse's Fifth Amendment rights, or this situation here. It just feels like time and again we see the Zachariah Anderson case with the way they handled it. They're set up to go after scalps, which makes them not acting in the interest of justice like they're supposed to be, but far too often makes them just headhunters who are all about winning irrespective of what justice demands, what justice should be motivating. So, but to the extent they would have any impact, it should have any impact on how much evidence, I don't think it should have any impact on that. I don't think it should, because it's not like just because if there's a preponderance of evidence, that means you're really not sure that there's anything here, right? If you can barely get past the preponderance of evidence standard, and you're struggling to get past that, So some people think the person that the DA did something wrong. A lot of people think the DA did nothing wrong. To me, that would be something that would be more of a reason to allow the DA to stay, rather than everyone being confident that there's some decent level corruption here, but not quite conflict. I spent too much on Flux, Danny, Jeff, etc. That's a big mistake. You gotta save some here. I don't know what to tell you. They're all great people, though. So, legend has it that Abbate is still umming in the courtroom to this day, almost undoubtedly. Fani definitely creates some slides to Adam and told him to follow them. I train weekly, and if I use other slides, I sound as terrible as he did. He was terrible. Oh, I see. You're too kind to me. Thank you, Jenny L. You're too awesome. Hi, thanks for all you do. Like and sub, good people. Amen. Like and sub, indeed. Cedar Rose says, don't listen to Joe. This is a 100 occult. Also, noobs only get off-brand Kool-Aid. There's no Kool-Aid. There's no Kool-Aid for anybody. No Kool-Aid. They have to prove themselves for the honor of drinking. I don't understand how this works. Maybe someone can understand this. You just were gifted a membership. I was like, I could have sworn she was a member. This happened with Riley Infusion last night also, where I saw he's been a member for like over a year, and he was gifted membership. Does that mean you jump up a level? How does that work when you get gifted memberships? I don't understand that. It's very weird. Here for the scrolls and was told there'd be Kool-Aid. There's no, there is no Kool-Aid. The Generations version of Frankie Pantagelli and The Godfather. Yeah, I can't show that. So Frankie was a better liar. I can't show that. If I show that, I'm definitely gonna get spanked by YouTube. And yeah, it'll cost me like way too much money to show that. So I'm not doing it. The appearance is enough. Yeah. From reasonable suspicion is greater than reasonable doubt. On behalf of Daily Quick Bites, Joe, see State versus Thomas, Supreme Court of Georgia, in which Fulton County Assistant District Attorney Adam Abbate does something naughty, perjury naughty. Really? Supreme Court of Georgia, in which Fulton County Assistant District Attorney Adam Abbate does something. He commits perjury? Really? Really? I have a hard time believing that. Let's get into Adam Abbate. I really want to get into this. So let's do that.
You've heard all about Whitworth. So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which a district attorney can be disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that there must be, by failing to disqualify the assistant district attorney, absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful. I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, or lack of better words, ditch effort that should be exercised as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney, unless an actual conflict of interest is what's found, Your Honor. And it can't be cured.
It's almost like he's boring himself at this point. Right? It's almost like he's boring himself. It's kind of funny.
So what I would reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talked about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context?
So
We're talking about,
So again, to remind you, we were watching this part a little bit very late last night. He's trying to make it as if he's citing a case where after the entire case was over and the criminal was convicted, criminal tries to appeal saying there was a conflict of interest that the DA had. Now, common sense should tell anybody that once you've gone through the entire trial process and you went through the whole spiel, jury instructions, trial process, deliberations, we find you guilty. All of a sudden now at the very end, no, there was a conflict there. There was an appearance of impropriety it looks like there were things that were improper by the DA. You can understand why the Georgia judiciary would be like, if you show me a conflict of interest, then maybe. But just the appearance of impropriety, I'm going to undo your whole conviction now. We know you're guilty. We have a jury that found beyond a reasonable doubt that unanimously said that you're guilty. So just because the prosecutor has an appearance of impropriety, we're going to undo this and pretend that there wasn't a dozen people here who just found you guilty of committing some potentially terrible, terrible crimes. That seems to be, you can understand why once there's been this unanimity of a jury saying beyond a reasonable doubt you committed, potentially violent crimes. You can understand why at that juncture we'd be like, yeah, there might have been an appearance of impropriety, but we're already past the whole trial already. It's all over. So unless you can show me an actual conflict of interest, at that point, all right, there's conflict of interest, then maybe, then I can understand overturning it. That would make a lot more sense. But when you're just talking about something like, when there's no conviction yet, we haven't started trial yet, you can understand saying we don't want to move forward in this case. We're carrying this appearance of impropriety because then we're going to be walking into a trial where everyone knows that there's this whole stench around the DA. And that's a reason to say, no, we're not allowing you to proceed here and act in the name of justice. You're standing up in the name of justice when we're walking into trial here and everyone here knows that there's this stench around you, district attorney. So you can understand why the bar for removing the district attorney and fighting in favor of defendants would be far lighter, far easier for a defendant before they get convicted than after they get convicted. That's just common sense. And Abbate here now tries to make it's stupid to make an argument that sounds facially dumb. Because when you make an argument that sounds facially dumb, you're basically telling the judge, don't listen to me. Don't listen to me. Because I'm going to throw out anything I possibly can, no matter how illogical it is, in the hopes that you're going to swallow it. Or I think you're not going to notice that there's a difference between post-conviction and that this case I'm just giving you here was post-conviction. Even though it's staring you in the face, I think you're too stupid to realize it. It's an offensive thing to do. It's offensive, and it's not offensive to me. The only person he's bringing offense to here, and this is another reason why this is such a terrible, terrible, terrible closing, is because he's basically spitting in the face of the judge, where he's either showing the judge that he hopes the judge is too ignorant and stupid to recognize that there's facially a huge distinction between removing a district attorney before the defendant is convicted versus after the defendant is convicted, or that the judge is too lazy to look and notice that that's a difference, even though it's ridiculous that he wouldn't, for the one case that sticks out there and says you have to show a conflict of interest, not just impropriety, that he wouldn't say, why would this one case be so different, and notice it immediately. So he's basically saying to Judge McAfee here, I think you're an idiot or lazy. And now the judge is calling him on it. And he's like, don't you think that is being a key distinction here? Don't you see that as being a key distinction here? So now what's he left doing? Now he's left making a ridiculously stupid argument, as he's about to make. Let's hear your stupid argument here, why there's no difference.
Competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction. And usually that's, kind of an entirely different standard where we assess as a totality, was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought, if you have any reactions.
Well, I think what Your Honor just said is pretty on point in the sense that if it's found that
So when he's saying you're on point, just to understand, that means everything you just said, totally right. Totally right. Which is what we're left with. So why did you throw this out here? Were you hoping he wouldn't notice it? Watch where he goes with this. You're totally right, but
if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to.
Phone a friend coming in here. Fani coming in as the phone a friend. Here's a little note I got for you saying you're fired. Because if she has any intellect at all, she realizes what a stupid argument he's in the middle of right here.
Yeah, I mean, I guess I'm borrowing kind of from, as we've been doing the other pretrial motions, special demurrers seem to get different treatment pretrial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and
but I don't have the answer to that.
Well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it's applied post-conviction versus pre-trial during pre-trial issues. And what I would say to the court is that.
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis you applied.
Well, what I'm citing.
Legal analysis.
I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor.
Water. I need some water.
What I can't do at the moment is point exactly to the page at the end of the state's argument. I can give you the page number as it relates to
so bad.
Bernie's order.
I think I know what you're talking about. The footnote where you references the appearance standard.
Yes.
All right.
Right. Further, in Lamb v. State, 267 Georgia 41, on page 42, it's a 1996 case.
You give me notice his left hand there sliding up and down the podium, trying to find some sort of comfort and like just massaging materials here to try and like grip himself when he's like struggling there.
Where the court says, nevertheless, the conflict must be palpable.
Whoa.
The state's argument, I can give you the page number as it relates to Judge McBurney's order.
I didn't do that.
The footnote where you references the appearance standard.
Yes.
Watch his hand like just sort of moving back and forth.
Further, in Lamb v. State, 267 Georgia 41.
Someone help me.
On page 42, it's a 1996
Someone help
case,
me.
where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same whether it's post-conviction or pre-trial.
Based on what? Based on what? Why would you think that? All you did was just basically cite a case which, as the judge says, a whole different category, not really relevant here. You say, well, I think it's the same. Why would that be? Why would that be?
In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia case cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged.
Okay.
So in the case that's been referenced by all parties here today, Whitworth.
So understand what he's saying here. Appearance of propriety is not enough. Even conflict of interest, not enough unless the nature of the conflict of interest that he's pointing to here has to be one that the prosecutor has a personal stake in getting this person convicted. Not just a personal stake, but a personal stake in the actual outcome of a conviction. So this is where, so there's like basically the only time a DA, according to his argument that he's trying to proffer to the court here, the only time a court ever has jurisdiction is how lawyers refer to as the power, the authority, the only place that you have even the right to remove someone. Not discretion, you have some discretion that you must remove him, which would be a different thing. But you have no right to remove someone based on a body's interpretation of law unless forget about appearance and propriety. You have no jurisdiction to do it there. Forget about conflict. Forget about ethical conflicts or anything of that. You have no authority to do it there either. The only time is if there's a personal interest that this district attorney has, personal financial interest in getting, not just personal financial interest, because she has a personal financial interest here. So it's got to be a personal financial interest in getting a conviction. But if it's just a personal financial interest, so what he's basically saying is, even if we knew that there is, according to him, even if we knew that there was evidence that Fani gave this case to her boyfriend and she said on tape, yeah, I'm hiring you, so this way you will be able to rack up tons of hours and have the money to take me on a worldwide trip because I plan on going to Nepal. I plan on going to Italy. I plan on going to China. I might even want to make a stop off in Russia. I'm going to be definitely making a stop in Ukraine, and you're going to be funding all of this, and you're going to have the money to do this because I'm hiring you to rack up the billable hours to go after this person here. According to his argument that he just made now, all that totally kosher. The judge has no jurisdiction, no authority to remove the judge and to remove a district attorney in that case. The only time you have authority to do that is if she makes money because of the conviction of the defendant. Someone's paying her by getting conviction. That's when you can remove her. Any other scenario, she's unremovable. The judge has no jurisdiction, no authority, no power, no right, no nothing. You had no permission by law to actually remove her from there. It's such a ridiculously stupid argument that to try to make this argument to the judge, when you try asking for something that's so crazy, all you're doing is you're basically telling the judge, I am thoroughly unreliable about any statements of law I'm going to make to you during this presentation. That's what he's essentially saying. He's not compelling. He's not something that he's someone you sort of look at as you're kind of a little bit of a loon here. I mean, you're kind of a lunatic. Yeah, if you think that that's the only place I have authority, I have the jurisdiction, all this talk and all these cases about appearance of propriety, the only time I have the right to remove someone is if they're getting paid based on the conviction of the defendant, and no other circumstances am I allowed to remove them, I think you're out of your freaking mind. So you're basically saying, why am I listening to you? It's like I might as well listen to some idiot on a megaphone in Penn Station there, who's basically screaming about how the purple beings are about to take over the earth. That's how crazy he sounds with this argument. It doesn't make any sense. But this is something MSNBC is like, oh, he's really good. This was really good argument. This was a great argument. Good job, Abbate. Good job.
The State 275 Georgia Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegations that.
So you want to cite to me this Whitworth case, which says if you only have speculation, you don't have real evidence of there being impropriety or anything of that kind, but you just have speculation, the judge not allowed to remove it. He's like, yeah, I don't think Whitworth applies anymore. And he's about to explain why.
There is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other. And if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of them.
But you can recognize that at the very least, an argument can be made that some people might conclude that perhaps she didn't pay back everything that she got from him. You recognize that, counselor, that at least there's a possibility of that, right?
Parties.
Right. But that's a facted issue, whether it was, split even, or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money.
Since it's not speculation and conjecture, all the things that Whitworth was saying is that when you only have speculation and conjecture, a judge is not allowed to remove it. And that's why the judge is like, you're citing to me Whitworth here. Whitworth is not applicable because Whitworth is when you only have speculation and conjecture. And we're definitely not in that. We're not in that story. We're not in that paradox universe right now. We're in a different, we over here in this universe are in a universe where there's been an admission of relationship, an admission of changing hands. So we're not in a speculation about a relationship type of universe that you wish we were in.
Change hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade.
There was testimony, if you watched the hearing with me, there was testimony where she was questioning about the fact that there's a lien on her house. He's saying that was only thrown out there to embarrass the district attorney. But the judge allowed those questions. The reason the judge allowed those questions is because it went to credibility when she says, I got tons of cash. I'm sitting on stacks of cash. Well, you're sitting on stacks of cash and you can't even pay off liens on your house. So that doesn't really sound like it adds up. You're just sitting on wads of cash and just deciding not to pay off liens on your house. So that's not thrown out there to embarrass her, even though she should be embarrassed by that claim. But the point was to attack her credibility when she's pretending that she's sitting on stacks of cash and yet can't meet her basic expenses.
And the point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court.
No, it's not her character as far as her credibility when she's saying, I sit on stacks of cash. I'm a freaking drug kingpin over here. You think I don't got money? I got tons of money to pay him back.
In front of anyone watching the proceedings as it unfolded.
Oh my God. The reason he's quiet, the reason is this is not his demeanor. We saw his demeanor throughout the hearing. This is a very different demeanor from what we saw throughout the entire hearing. He's popping up there screaming, this is attorney-client privilege. And screaming objection every 2 seconds with a lot of outspoken nature. And all of a sudden now he seems, when he's trying to actually put all this into something that sounds like a strong argument, his he's wearing his heart on his sleeve. And he's showing that, when he was screaming objection before and with all that passion and everything like that, that was desperately trying to keep the court from hearing evidence, not because he's standing up for justice. Because over here, when he's supposed to be giving a passionate argument as to how wrong this is, he realizes how stupid he sounds with some of these arguments. It's a tell. To me, it's a tell. This guy, he knows his arguments here are just empty. They're lame. And some of them are downright insulting to the intelligence of the judge.
The language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference.
And I want to be clear, I do not feel bad for this guy because he shows that he showed for every day of testimony, he showed that he's a complete douchebag a-hole. That's what he's shown over and over again. So no, I don't feel bad for this guy at all. And now he's standing up here trying to make an argument that he is really an argument being made in bad faith. I want to see this guy be humiliated. While I'm here on pause, I gotta call out here my girl Bella Stella. 20 good Lawgic memberships. God bless you. Thank you so much. New members are the following. People need to thank Bella Stella include Tay Marie, Dust in the Wind, Blue Sky, Mingo, Justin Hayes, S.A. Alba, United We Stand, John H., Deep Pool, Daily Quick Bites, all these fine folks. Daily Quick Bites gifted a membership by Bella Stella, as was Just a God, Prospering Woman, another. Oh, not Prospering Woman. Sorry, you didn't get one. Sorry, Prospering. Maybe next time. You got one yesterday. I was wondering how you got another one. Queen Olive, Juju Queen, Rob Price, Kelly R., Brian Dunham, Moose Nut, Bill Leslie, Randy C., Sherlin. Unbelievable. God bless you, Bella Stella. I'm going to give you another one. It's very cool of you, Bella. Thank you. Let me take care of a couple of other bills here that I got to pay. No Kool-Aid. We drink Flavor Aid. Kid tested. Jim Jones approved. No, there's no Kool-Aid. There's no Kool-Aid. See, even Squiscar here is agreeing. No Kool-Aid. Stop with the whole Kool-Aid talk. This is a weird riddle, but I couldn't stop laughing when I had this thought. Is he gay or is he nervous? LOL, you can't. It's a riddle without an answer. Look at how Trump's lawyer grimaces in the background because he knows how terrible this is. He's a really smart attorney. He knows. Many lawyers, not good logic. All hail Joseph Leader. And no, not Leader. Finished last in the law class. The lawyer for Fannie may be owned. Yeah, Joe, please turn the court audio up. You're much louder than the court. If I turn my end up to hear the court, then I go deaf when you speak. Can I turn my own volume down? I can turn my own volume a little bit down. I'll do that. I'd rather turn my own audio down. Because otherwise I start getting a headache when it's like too loud for me. I'll turn my own audio down a little bit. Hopefully that's better. LNC version, long crime version shows Fanny live during the argument. Really? Really? Let me watch the long crime version. That probably would be interesting. Now I got to figure out how far into his thing we are. This is we're at 2:17:58, and he started at 1:40. So that means we're 47 minutes into his argument. So I go to long crime. All right, just to. I'm going to sit here trying to figure out volume levels all over again. God help me. This is not what you're telling me. Knack. That's not what I wanted. Let's see videos. It's an hour and 27. Is this it?
I want to start with some of the things that were addressed over the last hour and a half. First, beginning with something that he paid off the assault victim. Eventually it started with an escrow account and led to statements that had been represented by defense counsel that he allegedly had made in the past. It was
I'm not seeing much
important
Fani Willis
to,
here anyway. So I'm going to respectfully decline this. And I also don't like the volume levels. It's kind of throwing me off a little bit. So let's go back. Let's stick where we were. But I appreciate the thought. TBF is not thrown out. Do we want competent state or this one? That's an interesting point. You think it's going to be better? They might not even take the case. Whoever is given to might not even take the case. So, show me the money. Show me the money. The attorney is happy and eats the bugs, the lawyer of the future. Probably. Sounds like you're reading horses near the end of a race when reading new members. And down the stretch it comes. There's Worcestershire down the stretch. H. Coffee, Janella. And coming out, Laughing Eyes by half a head. Laughing Eyes by half. Don't call him leader or he sends us back into the tunnels. I don't have the authority to send you back into the tunnels. Now get back to work, please. J.H. Schwalbach with the big rumble rant here. I'm about to do my taxes, and my tax man said that if I give money to a cult like Scientology or cosplay or even the Almost Mighty Joe, I can get a tax write-off. Please send me our tax. It's not at all a cult. Type of cult. It's not at all a cult. Not at all a cult, but thank you for the love. Thank you so much. Bill Doe says he's speaking like a college student, writes a paper to get more pages. It's almost like he's trying to fill his 90 minutes part of this, right? It is, right? It's like he's trying to fill his 90 minutes here. Thanks for the tip, Trigger, while you're here. While I'm here, taking care of all my bills here. He does sound like he sounds like he's working really hard. Like he's working really hard to fill time.
To speculation and conjecture is again a reference. Because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.
He's like, let me get something that he might listen to because nothing I'm doing so far is working.
So in State v. Sutherland, which is 190 Georgia Appeals 606, 1989 case, and it says while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial function in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a prosecution because the state is always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of.
Well, let's give you a new note. Because you're struggling. He's probably sitting there thinking, he's like, I want to see one of you try to make an argument here. Let me see you do better. Our case here sucks. Let me see you do better. Coming up here, handing me notes.
So I want to move into.
It's almost like from the clunky shoes they're wearing, it's almost like they didn't expect to be wearing a path through the carpet to walk up to him while he's in the middle of his arguments, right? I mean, you would think that they would have gotten sensible shoes, something that would impress one of Forrest Gump's benchmates, or something that someone sitting on a bench with Forrest Gump would be wearing. If they're going to keep on strolling on up there, rather than the clump, here I'm coming to hand you a note type of deal. but I guess they didn't foresee him drowning quite so badly that they're gonna have to come in there and just sort of keep handing him one buoy after another for him to cling on to.
I guess the evidence that Your Honor
Tell us about the
saw
evidence.
and heard during the last couple of days, 3 total days of testimony as it relates to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here.
What I love
before
here,
the court, that
he's reading this. He's reading off all these PowerPoints to him. He's showing him the PowerPoints and reading them to him. Which this is just not the way you do PowerPoint. It's not. It's not the way you do. The point is that you're adding something, but he just like lists off, like, you know, and she's a former employee, disgruntled employee, and he's a former disgruntled. Everyone who was fought against them is a disgruntled employee. And I'm going to appeal to you through intersectionality that because of who by virtue of who these people are, obviously they would never ever lie to you.
all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation.
Now, if he was a genuinely skilled attorney, what he would have done is, when he's talking about Bradley right here and now, he would have laid into what the judge basically was alluding to when he was questioning the defense. One of the things that MSNBC host Lily Fang, or whatever her name is, was trying to cite as far as reason for optimism for Fani Willis is how he was, quote unquote, peppering the defense with questions. Peppering, which I thought was a comical use of the term peppering. If anything, seasoning and spicing up is how I heard it. I don't know if it was simply pepper. It seemed like there was some garlic in there. There was some onion powder. There's all sorts of seasoning he was adding into it. But one of the areas that he threw out there, which I thought was something that he's likely grappling with, and that Abbate, at this point in time, when he's talking about the credibility of the witnesses, this is precisely where, if he wasn't stuck to the script of what was written in PowerPoint by Fani, and this was almost certainly written by Fani, that if he wasn't stuck to this stupid PowerPoint, he would have branched off into what the judge said of saying basically this is how you make an argument in a losing battle that actually sounds correct. Think about what the defense is asking you to do with Bradley. He's a key witness here for the defense. They said from the get-go that he's a key witness here. He's the key witness. And he got up there. He said nothing supporting their case. Nothing supporting their case. And they would have you disbelieve everything he said under oath. So he said, let's get him up here under oath. And then based on what he says under oath, after everything we saw, what he said under oath, they're saying, don't believe anything he said under oath. The only time we should believe Bradley, if you're the defense, is when he's not under oath. Think of how illogical that is. Think of how backward that is. This is why you should just take all of his testimony, all the things that he ever says, and recognize that he's someone who cannot be trusted, no matter the context, no matter the setting, no matter what he says, he cannot be believed. And their whole case is resting on him from the get-go. From the get-go, they were like, look, we have all this stuff from Bradley. We have all this stuff from Bradley, all this stuff from Bradley. And at the end of the day, they now are in a position of telling you, don't believe anything Bradley said. Don't believe anything he said. That's how Abbate should be presenting this. But instead, he's going to, he's a former friend. Don't believe him because of this. Don't believe him because of that. It's like, it's so stupid. It's so stupid. It's such a pathetic way. I get frustrated seeing people lawyering poorly in positions where this is someone who's supposed to be an expert litigator. You're supposed to be prepped for this. You're supposed to be, you had, days and teams of people working on this together. He's not who are all able to give their input as to the best way to put our best foot forward, and instead they're like they go to the old standbys of like, don't believe him because he's a disgruntled employee, disgruntled former partner, and this is why you shouldn't believe. No, you should basically say they don't want you to believe him. The only time they want you to believe him is when he's not under oath. How backward a court system we have is like the only time we believe someone is when they're engaging in hearsay, but not when they're testifying on the stand. It's the exact opposite of all principles of evidence is what they're asking this court to embrace. That's how you make the argument. That's a real argument. That's an argument that you saw the judge himself was struggling with, that he sort of was trying to wrap his head around. You saw him make that point, that very point to the defense an hour ago. This is where you break away. But he's too weak an attorney, fortunately.
I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who
from the first female elected attorney, district attorney. This is how you know it was written by Fani Willis. The first black female elected as district attorney. It's like just, God, that's how you know it's truth, because it's coming from the first female district attorney, who's obviously also an interested party here.
Was a 40-plus year practicing attorney.
Yeah, he's also part of, what was it, the Weather Underground, Black Panthers, and how many other stupid groups is he supposedly affiliated with? These radical, crazy groups that he's affiliated with. That's the guy who you need to believe. And also happens to be like the de facto defendant here, because she is the de facto defendant. She's defending her improper conduct, so she's sort of become the de facto defendant. He happens to be the dad of the de facto defendant. That's why you should believe that. Not all a question about his credibility.
Good standing when he left the practice of law.
Nice.
And what I would submit to the court is that Miss Verdes.
Oh, and he also happened to be planning his testimony together with his daughter. Another ridiculous element here. That when he got off the plane, he sat down with his daughter to figure out what his testimony was going to be. Total credibility.
Testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then they could have dealt with privilege issues and whatever else.
This is a great point that he's making here. In case he drifted out because his tone is so nervous that he sounds a little bit boring and it's easy to space out what he's saying here. He's trying to say that you shouldn't believe Yurdy. The part of the reason you shouldn't, the argument that Adam Abbate is trying to make here is this. Before the evidentiary hearing, when the judge was trying to decide, should we have an evidentiary hearing? So there was a court conference that was on Zoom that we covered, wherein Miss Yurdy's attorney stated that Yurdy doesn't know anything. She doesn't know anything about what happened. Then she gets on the stand and she seems to know a lot. She was very damning in her testimony, saying that they met in 2019 at a judges conference, and shortly thereafter they were in a relationship. They were in a personal, physical, romantic relationship that started shortly after they met, late in 2019. So it started either in late 2019 or early 2020, according to Robin Yurdy's testimony. This is after her days earlier, where her attorney said she doesn't know anything. So Abbate's trying to make the claim that when her lawyer comes in open court and makes a statement that she doesn't know anything, the only way he could know that is if his client told him that. So when he makes that statement before you in open court, that becomes her adoptive statement, which she later conflicts through her testimony. So her testimony now is inconsistent, and she's trying to use what he's implying. I don't know exactly what she told her attorney, but we can draw conclusions about what she told her attorney based on what he told the court. So clearly she's telling her attorney one thing and then coming in here and telling us something that is the opposite of what she told her attorney. So that being the case, that's a reason that you should not give her credibility. The judge is asking a great question. He's like, is there evidence that what she told her attorney? How do we know what she told her attorney? Maybe he misunderstood everything. There's been no cross about what she told her attorney. There's been no anything about that. So how are you now coming along and saying that's an impeachment of her testimony? That's a prior inconsistent statement when we don't know what the hell she ever said to her attorney. Now, frankly, if she had been, and he's saying you didn't even cross her about what she told her attorney. Now, frankly, if he had tried crossing Yurdi about what she had told her attorney that led her attorney to come into court and say that she doesn't know anything, there certainly would have been an attorney-client privilege claim that would have kicked in there, which we had so many of those. We can be positive that would have been one that the defense and Miss Yurdi's attorney would have been screaming attorney-client privilege.
I would agree with the court. It's not an evidence, but it was a statement by an officer of this court.
I love how they're being hoisted on their own petard. This guy right here is being hoisted on his own petard. Okay, and the way he's being hoisted on his own petard is he spent days and days screaming attorney-client privilege. You don't know anything. Attorney-client privilege. Attorney-client privilege. We don't know what happened. We don't know what Wade told Bradley. Attorney-client privilege. Attorney-client privilege. Over and over again between Wade and Bradley. So you can't draw any inferences. You can't take anything. No, attorney-client privilege. Attorney-client privilege. Attorney-client privilege. Now he wants to try and insinuate what we derive from conversations between Yurdi and her attorney, and the judge is like, what? How? That's not on the record. And he knows that if he would have asked her these questions, he would have been hit with, you can't ask that question. That's attorney-client privilege. It's being thrown back in his face. There's so much delicious irony in this case. So much delicious irony. I'm convinced of the fact that this topic, this whole hearing is so wildly popular. I know when I'm talking about Fani Willis, you can get twice as many people watching me at the very least, if not more, watching. Because I've thought about why is it that everyone is so consumed with this particular story? And the reason is it's because we feel like we're actually seeing justice. Like Ursula, the sea monstrous, right? The sea witch over here, Fani Willis, getting her comeuppance. And we're watching it happen in slow motion. We're watching that comeuppance come, where she came out there talking about how she's like this pure person looking out for those poor unfortunate souls in pain, in need, and that she's this virtuous woman here who's standing up here and swinging her body language around and that she's finally being exposed. And I think there's a delicious irony, delicious irony that's what the public is salivating over watching, because we see how much hubris she has, how much gaslighting she engages in, how she's a pure race baiter, how she's raging TDS, and that she's all about her self-glorification, stepping on others and claiming she's a victim while she's actually oppressing others. And we all see it. And watching her come undone while being humiliated in the process, it feels like there's vindication, not vindictiveness, but vindication. That changes everything. It goes that the public has a hunger to see this vindication and to watch that in every little element, them coming undone, that they tried standing behind this attorney-client privilege, and now watching him being hoisted on his own petard of attorney-client privilege, getting in the way of him being able to show if there was any prior inconsistency in Robin Yurdi's testimony. I think it's delicious irony. It's an amazing thing to watch.
To the court during a hearing related to her testimony and how we were to proceed with her testimony in this hearing. But I would, it's clear that what was represented as to why she would not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify.
You don't know that.
Under that theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Great question by the judge. So if you think that she did a 180, why did that happen? Why would she tell her attorney, I know nothing? And then on Monday, and then come in on Thursday and say, oh, I know everything. Well, what's her incentive for switching that around?
Where did the incentive
So
arise?
she was fighting so hard to avoid if we're going down that road you proposed, she was fighting to have not to come in here and testify at all. And then she comes in here and testifies. Why would you testify the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her
Great
interests
question.
and these kind of things, I don't know if I'm quite following.
You want me to try looking into her brain? All right. Well, let's look into her brain according to the way you're looking into her brain. You want me to look into her brain as to what she's thinking and saying that she was thinking one thing on Monday and something completely different when she actually opened her mouth on the stand on Wednesday. Okay. Well, walk me through it. Tell me why she did this 180. And he's like, I don't know. I don't know. But he actually comes up with an answer here from what I recall.
Following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum
Yeah, that's kinda
where
weak.
she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it is ultimately when she was forced to testify, right, a motive and a bias as to why she testified in the manner in which she did.
No, it would be completely opposite. Completely opposite. If you're saying the reason she wouldn't want to take the stand is because it's a public forum. So what you're essentially saying is she lied to her attorney to try to get her out of having to take the stand. But then once she was put under oath, that's when she finally told the truth. That's all this guy just stood up there and said. He's like, wow, she didn't want to take the stand because it's public. But now, but then when she did take the stand, so maybe that's why she would lie to her attorney and say, I don't know anything. Tell him I don't know anything. That way I won't take the stand. But once she was put under oath and that didn't work, well, now she had to tell the truth. So she did.
Asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross asked her about
that was embarrassing.
whether she resigned or forced to leave, she was fired. She came out and said she was given the choice, you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired, and when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed. But it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would.
But if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that.
I don't know. That's essentially what it's saying here. She didn't want to come on TV because she was having a bad hair day. So she just didn't want the public to see her with her bad hair that day. So that's why.
Well,
I
I
don't
don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high profile of a nature where everybody would be able to watch and learn at what she has to say as it unfolds in the courtroom. And I'd further submit to the court, there is.
And then she could have just said, I don't remember, if that was her motivation. That way she's not in the spotlight.
Reference to she left the DA's office in the text message that were submitted in, I believe, what is it, Defense Exhibit 39, that it's because she released confidential information
Relevance?
in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
I haven't seen anything he said so far. Anything he said that's like remotely convincing of anything. And the judge just seems to be sitting here just just knocking him down. Boom, 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 one after another.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. He, when pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area.
It's funny, he said topic, but the voice text thing said toxic. Look at that.
Would go into such
he says he's about to say topic, but toxic is more appropriate because it was so toxic for the state to actually go into it. It helped destroy their case.
A topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And
she definitely wrote it.
When Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that.
It's Church Current Makes Tax Not a Cult. Thank you, Larry Johnson, for the tip. We've lost interest in this guy, yeah, but he's fun. He's fun to make fun of, and I think it's important to show all the different ways that he was flailing hopelessly around. And no, I agree with you that the notes are not helping me. Joe's voice is so soothing. Let me just take a nap real quick. Joe, 10,000 gifted memberships. I'm sorry. The fact that they're holding on to this case so much is proof that the corruption because of it wasn't. She shouldn't care if the case gets passed on. It's a great point. It shows how much it's all about her. It's like, I don't want someone else taking this scalp. I need this scalp. This is from the team that has a 95% win rate. You got to wonder about that, right? It's probably down to 94 now. It's probably down to, I'm just guessing, down to 94. Thank you, Shayla Mang, for the super sticker. I appreciate you. You awesome. What chance these fans sue Fulton County for malicious prosecution after Fani is bounced? 0. That's not going to happen. That's just not going to happen. Joey, watch the PowerPoint. Oh, yeah. Okay. I'm sorry. Let's get back to the PowerPoint presentation.
More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account, led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into
she got drunk. She got
the
drunk.
end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements.
Not quite,
In order
Johnny
for impeachment
Cochran.
to be proper,
Definitely.
he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear.
Yeah.
As it relates to his disdain.
Yeah, and when he said, I don't remember, that was the lie. That was the lie. When he was saying, I don't remember, that was the lie. He had every motive to lie. What did you guys do to him to give him those motives?
Towards Mr. Wade, which due to the fact that, he was expelled or exiled from a thriving law practice, and it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a
look at the PowerPoint there. Basically, what it says, Merchant presents to this court that Bradley had firsthand knowledge of it, and that would be something. And then she wrote, lies. Who do you think wrote that? You think that was Adam Abbate that wrote that? You think Adam Abbate wrote lies? You think that was Adam Abbate? I don't think so. No. My gut says that was Fani.
promise that was also made that he would.
Childish. Lies. It's so stupid. Because, yeah, you know what? When they were looking to get a hearing, Bradley was cited as being the key point here. But once Robin Yurdy took the stand, everything changed. Once she took the stand, everything changed. Because we had right out of the gate, firsthand eyewitness account claiming that them two were acting like lovebirds years before Wade had put in his affidavit. And then Wade got on the stand and he starts introducing new stuff about cash that we had never heard beforehand. He didn't put it in his affidavit. Why didn't he put that in his affidavit? No one knows. He couldn't answer that. And then Fani comes in here with her do you smell what the rock is cooking moment, and she's getting up here. So yeah, Bradley sort of became an afterthought at that point. You don't always know how things are going to play out in a hearing, and to start saying that that's a lie is such a silly reflection of assuming that the judge is too ignorant about how cases and trials tend to play out versus expectations versus reality. So that doesn't make it a lie. It just means that we don't need him at this point. And when you look at the phone records, you look at the text messages in full, you can understand why Ashley Merchant wasn't lying, but that Bradley was the one who was lying. But you're sitting here saying, lies. Like a screaming chimpanzee. It's craziness.
Be able to impeach the investigators as it relates to cohabitation was mere speculation, gossip, and innuendo. And this is, Your Honor.
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking?
This is from like, I think it was the Monday before the hearing started, when the judge was trying to decide whether or not to have a hearing.
Well, essentially, that kind of seemed to be.
And it's not witness testimony. They're labeling this witness testimony. This is the attorney arguments as to whether or not it should be a hearing.
All of them. You had said Allen, Bond, Young, and then the investigators Hill, Green, and Ricks could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
In reference to your question, the unequivocal answer was yes. And when Your Honor.
Yeah, and we all saw the text messages between Merchant and Bradley, which would lead anyone to conclude that she was correct. It would lead anyone to conclude, just because he ended up recanting that later on doesn't mean that she's a liar. It means Bradley was lying when he said he didn't remember anything. And everyone knows this. This is why it's such a stupid argument. It doesn't do anything. You think the judge wasn't there? You think the judge forgot how everything unfolded here? It's such a silly argument.
Looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses.
He said everybody knows. That's what he said in his text message. So, yeah, and that they would all cover for her. So, yeah. Everything she said bore out in those text messages, and now he's trying to assume, I guess, that the judge hasn't read the text messages that everyone else on the planet has read. Okay,
Mr. Bradley.
You do you, Adam. You do you.
What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation, because it asks, do you think it started before she hired him? And he says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court as to a lot of things. Other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley. And I would submit to the court that conversation never occurred. That would be the state's contention. And how
see, this is when you're so desperate. You're so desperate. This is literally throwing any. I would submit it never occurred. The dude told the judge about it in chambers, this conversation. That right now he's trying to convince the judge that a conversation he was not present to, that Bradley was clearly very reluctant to ever discuss with anyone, that Wade brought a motion saying, you can't even talk to him in private. And the judge laughed at that motion, didn't even bother responding to it. He just ignored it as if it never happened because he thought it was such a comical claim that Wade was making. And then he gets Bradley into his office, and Bradley told him about this conversation. And the judge had a chance to vet it out, and he was sufficiently compelling that the judge is like, yeah, we need to get this on the record. So we're going to reopen testimony and put you back on the stand for a freaking full day. But now he wants to convince the judge that which the judge heard in chambers, that you're wrong when you gave him any credibility there. It never happened. It never even happened. It's like when you don't realize how bad your farts stink. That's what Adam Abbate is practicing right here.
we know that. We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially.
He wasn't confronted because he kept hearing privilege, 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 privilege. That's why he wasn't confronted. And the judge knows this too. This is such a terrible argument. Oh my God. I forgot how bad this was. This is terrible.
And I'd even say direct as to that conversation non-existent, because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found. That
Yeah,
would have
but
been
he
relayed
said
to
it
Ms.
was
Merchant.
privileged. He said everything was privileged. That's what he said on the stand.
And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against.
Oh my
And the
God.
reason they didn't do that was because it didn't exist.
What a look at Sado's face. Are you out? He's like, are you out of your freaking mind? Are you out of your freaking? That's his face right there. Look at his face right here. He's like, are you stupid? Do you not remember sequence of events here? That Wade got on the stand, and then Bradley got on the stand, and Bradley was asserting privilege. And anytime we asked him anything about conversations with his attorney, he said privilege, and I'm maintaining my privilege, 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 privilege. And now you're sitting here saying that the only reason you didn't ask him about this conversation was because we were like afraid of it. We're afraid to confront him on it. Are you out of your freak? Look at his face here. He's like, I can't believe you were making this claim in court. And this is what Sado's going to hit him on later.
Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did it wasn't that just Ms. Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Ms. Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Ms. Willis. He specifically said he kept a lot of his disc jockey equipment as he.
Yeah, by the way, making an argument that like Fani is a two-timing hoe, not really an argument that I expected him to go with here. It wasn't just Willis, it was also Deuce. Why does everyone think Willis? You guys think that she's like a one dude kind of gal? No. Some dude named Deuce is part of her carousel there of dudes hopping in and out of her bed. Why is everyone making such a big deal about Wade? What about Deuce? Don't you feel bad for Deuce? Deuce got a toothbrush in her bathroom too. I don't understand. Why is everyone making such a big deal about Wade? Don't you know what a hoe she is? Seriously. What were you thinking? Why is everyone making this? Oh, Wade. This is like, it's insanity. This is insanity. This isn't his closing, which is why it's so terrible, and he has lack of emotion. Also, he probably doesn't believe it. Could be. That actually makes a lot of sense. It's hard to sort of take someone else's argument and then stand up there and do a compelling job with it. So it could be. It's a really good thought. And it's more true than people realize. When you write it yourself, or at least you're the significant contributor to it, you can start feeling the passion to it. There's zero passion here. He's just thumping and umming and eyeing his way through here. And it really could be that it's because it was written by Fani. And it certainly seems like I don't know it was her that wrote it, but it certainly sounds like it was her that wrote it. That's for sure. And on my almost 2-year total digiversary, I shall remind you, Joe, that it is Shilomang. It's okay. You'll forget again. Shilomang. I apologize. I'm so bad with names. I apologize, Shilomang. You are awesome. 2 years. 2 years of me calling you Shilomang. Shilomang. Shy. It's you're talking about shying, and Jews don't really understand that. So Shilomang. That's a better name anyway. I should remember that. Shilomang. All right. My apologies. You're awesome. And you know what? For 2 years, I'm going to give you one of these. For even almost 2 years, I'll give you this. Even though it says member for 5 months, but I know that that's YouTube's stupid calculations. It is almost. I know you've been here for years, so I'll give you the war horn and tell you my apologies. I am sorry. It's rude of me to not remember.
Is how he referred to it when before the court. He made very clear that he had never seen Mr. Wade at the South Fulton home that is owned by Ms. Willis. He made clear that he lived in that home with Ms. Willis and Ms. Willis alone, other than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Ms. Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021.
And no one believes
he then
that.
expressed to the court that Ms. Willis moved in the spring of 2021.
Not relevant.
And that due to these
Not
threats
relevant.
that were taken very seriously, he had only seen his child 13 times. He said,
Yeah, and he stayed to protect the home, which makes like no sense. We don't care about his life.
in reference to the questions by defense counsel that were in a, and I'm just going to be straight up with the court. They were trying to make Ms. Willis a liar.
You trying? But wait a second. She's the district attorney, the first female district attorney in Fulton County history. So how could they make her a liar? How could she ever be a liar? She's the first female district attorney in Fulton County history. That doesn't even make sense. Why would they even be trying that?
How I would submit to the court in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was the home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court,
blood, sweat, and tears. She just had liens on it. That's all. While sitting on fat stacks of cash. Liens on it. Fat stacks of cash, but blood, sweat, and tears. You see, that's what I'm thinking here. But to be honest, if I was the attorney, I wouldn't raise that because it sounds petty when you raise that for the judge, right? It's going to come across as being petty. But I'm talking to you fine people. Yeah, blood, sweat, and tears. There's someone else's blood, sweat, and tears because you borrowed the money. She never bothered paying for it. At least, or maybe she bought it and couldn't afford to pay for it. I don't know. Or she just decided not to because she's sitting on fat stacks of cash.
That he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Ms. Willis, but failed. Would be this how the state would characterize it.
Yeah, that's how the state would characterize it. The rest of humanity characterizes it as, oh my God, she's liar. The rest of humanity would characterize it as, liar, liar, your pants are on fire. But that's not how the state would characterize it.
He testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office. And he talked about how he kept cash in his home and why Ms. Willis kept cash in his home. And what I would, what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel.
The state should also take note of the fact that he admitted that as soon as he stepped off the plane, he consulted with his daughter about what they would say, what he would testify about. So, yeah.
So there was I guess, an implication that Mr.
Apparently, fat stacks of cash
Floyd
that she didn't pay her bills with.
Due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it. Did it follow her, where she laid her head, and things of that nature, trying to further discredit the practice that.
I just want to pause and remind you all that she is facing an ethics complaint, which we expect to be live streamed on Thursday, this coming Thursday, the 7th at 10 a.m. And I will be live streaming it, assuming that it's available anywhere, which I'm 97% sure it will be. I anticipate that I will be live streaming it. And it is important that the judge will likely sort of get a vibe as to how things are going for Fani Willis beforehand. And if she starts getting hung out to dry, and there's a good chance that evidence will come in here in this ethics committee, it's not going to be, this is what I like about this ethics complaint. It's not going to be just about her love life. We're going to hear about all the improprieties, because there were 5 or 6 at least, which were raised in this ethics complaint. 5 or 6 issues, and they all start coming out. So we start smelling just how terrible she is. Potentially a whole new evidentiary hearing. Whatever it is, I'm going to be live streaming it. I don't know if it's going to be, as I said, I don't know if it's going to be 1 hour. I don't know if it's going to be weeks and weeks of testimony, which it very well could be. But she certainly can face discipline, serious discipline. She could face disbarment. In theory, she could face imprisonment if she's found to have committed perjury. Because they likely are going to ask her to provide receipts to document the thousands of dollars she put up there. That's one of the things that if I was sitting on the ethics committee, I would start demanding that she turn over. And when she can't turn over receipts or some sort of accounting even to explain this cash that she supposedly is sitting on in her house, that she can be facing serious repercussions. We won't know until Thursday. They might treat it as like, a little way of that they might just give her a little do better next time, keep better records. That could happen. We don't know what's going to happen, but there certainly is a very real possibility of genuine repercussions happening. We won't know until how things are going for her until Thursday. And it really could be just nothing but a slap on the wrist, or it could actually be suspension, disbarment, imprisonment. Nothing is off the table as to what it can ultimately be for her.
That she had as it relates to keeping cash in her home, and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of.
But I'll also point out this. Remember how I mentioned earlier, this is an important thing to take note of. Remember how I mentioned earlier how the judge has very, very broad discretion, because there's a recognition that he alone is in a position to sit there and vet out these facts and sense their credibility or lack of credibility, and which witnesses sound more credible than others. And because of that, the law will grant him very, very broad discretion and how to determine whether or not there is a mess. And if there is a mess, how that mess should be cleaned up. Whatever he decides is almost certainly going to stand. It'll be appealed. Whatever he decides is going to be appealed, and very, very likely it will ultimately stand. I would say like at least a 90 to 95% chance, whatever he says, whether he says no punishment at all for anyone, or whether he says everyone gets tossed out of here. Either end of the spectrum that he says ultimately will almost certainly stand. That being the case, so now he can do whatever he wants. If the ethics committee engages and says we're going to have a whole evidentiary hearing here, he's going to be able to, in theory, if he's so inclined, to follow that and see, is this a woman who's on her way to potentially being suspended for this conduct, or worse, or much worse? And if he senses that, it is far more likely that his why discretion will lean more towards getting rid of Fani and her entire office. Whereas if he senses that they're just giving her a slap on the wrist, it gives him a lot more leeway for him to say, oh, look, the ethics committee didn't see anything wrong, so I don't see that much wrong here also. So I think it's a highly significant thing. Is it supposed to influence him? Is he supposed to be listening to any evidence to sway him at all? No. Politically, does it make sense that he likely will? He's human. He's human. A lot of people would. He's not supposed to. I'm not challenging his integrity. He's so far he's displayed a great deal of integrity and intellect. I don't know how he'll fan out at the end. Pardon the pun. But yeah, so that's why that ethics committee hearing can be highly significant, far more significant than people may realize. Even if they just have a hearing and don't reach termination within the next 2 weeks when he's supposed to give his decision, he'll be able to smell how things are going for her. He'll be able to smell that out before them.
Is that there was no evidence that controverted that at all. Where was the evidence that controverted Ms. Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence it was substantiated through the testimony of.
How would anyone have evidence of that? And the truth is, there is evidence against it from her failure to produce any sort of records to document it. She could have. She has access to those records. No one else does. That's the most ridiculous thing in the world. This is so many weak arguments here.
Of her father, Mr. Floyd. Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade.
I'll tell you that I don't remember, but and I wasn't really fixating on whether he was asked to just join the prosecution or lead the prosecution. If the judge is asking this question, it means he probably was attuned to it while Roy Barnes was on the stand and looking for that word and didn't seem to notice it. So when he's asking this question, it probably means he was never asked. He was never directly asked to lead. Or at least he didn't. Maybe he was asked, but the judge feels he didn't testify that he was asked to lead, and that's why he would ask. Because he clearly, this judge, like I said, very smart guy, and he clearly was paying very close attention to all of the testimony. And if he's asking the question at this stage and he hears that word lead, every time he sees Adam Abbate say something that doesn't jive with what he recalls, and that's why he's like, "Look, maybe I'm mistaken. Are you sure he said lead? Are you sure? Are you sure?" That means he was listening for it. That's the only reason, because he wouldn't be thinking about that unless he was listening for it in real time while Roy Barnes was actually testifying. So it's an interesting catch by the judge.
Is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it'd be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead
at that
prosecutor.
time as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because
I totally agree with you,
he
Mingo.
didn't pay enough. He said he had mouths to feed at his law firm, and that he
That
also
is
didn't
hilarious.
want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel
I don't
is
recall.
asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore,
Makes no sense.
if you were to
Come back to the
believe
Chewbacca defense.
the
It
claims
makes
and
no
allegations
sense.
as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gay Banks, in addition to Mr. Wade. If she has this grand plan scheme
I don't like how he calls him Gay Banks. That's not cool. That's not cool.
in order to profit off of the prosecution of this
He's
case.
assuming the
'Cause that's
man's
what they're saying.
sexuality there.
Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd. And it's desperate. It's a desperate attempt to remove a prosecutor.
It makes no sense. Why would an 8-foot-tall Wookiee live on Endor with a bunch of 2-foot-tall Ewoks? It makes no sense. Nothing. What I'm saying makes no sense. That's because nothing here makes any sense. And that's why you need to, when you're looking at this motion, you need to realize it makes no sense.
From a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? That's not, is that part, how's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made.
This judge misses nothing, and he still keeps trying to stick stuff in there that apparently was part of the record that this judge is like, that's not on the record. That never happened. That didn't happen. That didn't happen. No, that didn't happen. This is peppering.
I understand Your Honor's position as it relates to
Trying to make
that.
sure we know exactly what is in the evidence.
Thank you, me.
Regardless.
God bless you,
I think
brother.
Your point is made.
I think it's in evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney,
Judge doesn't care
Willis,
about that,
Mr. Wade, as it relates to how they met, how.
On this issue, which was raised in the motion, and the reason it was raised in the motion to basically say is like, why would you pick this guy if not for the fact that he's just a boyfriend? They pointed out his lack of qualification. The judge says, to my mind, he said specifically, to my mind, anyone who's admitted practice law in the state of Georgia is qualified. I don't care what they've done in the past. They're qualified. I'm not going to hear that. So I don't want to, so yeah.
How or when Mr. Wade became the special prosecutor, when there was.
I don't agree with his perspective on that, but that is his perspective. Not for purposes of saying he should be removed, but for purposes of showing that there's shenanigans going on here.
Relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurdi. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdi was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdi had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continue to be in a relationship 2019, 2020, 2021, until their relationship ended due to her forced resignation and splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Miss Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which
This is so bad.
it's the assertion of defense counsel that what those show is that Mr. Brad.
I gotta tell you, on review, this is even worse than I remember. I thought he got better as it went on, but this isn't getting any better. There's no points that are getting scored here. And there's so many whiffs and so many times that the judge is like, I don't remember that being in the record. I don't remember lead attorney. I don't remember there being testimony from Roy Barnes about this. Are you sure? This is not getting any better.
Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have.
Well, it's a fishing expedition that seemed to have struck a freaking whale because they end up admitting, yeah, we were in a relationship. So, yeah, fishing expedition that somehow shows geo records where he's spending the night with Fani Willis. I don't know. Those phone records are so damning. They are so damning. They're really destructive. Because it basically shows you can't believe anything Fani said. You can't believe anything Nathan said. They're a bunch of freaking liars who are happy to perjure themselves on the stand, and in order to try and protect their interest in this case, which only shows how desperate they are to stay on this case. And that also shows this is not about interest in justice. It's their interest in their own personal glorification. So that you're willing to perjure yourself and risk your livelihood to stay on this case. There's so many mistakes that the state made here. So many huge mistakes, massive mistakes. What they should have come out from the get-go is they should come out from the get-go with when the relationship started. Yeah, they were an item. Yeah, okay, big deal. They were an item. There's no motive. That's a minimal. That the money they got you're talking about here is so de minimis. Like, come on, that's how they should have approached this. It's their cover-up which makes them look so freaking guilty. It's their stupid, pathetic dog ate my homework. No, it doesn't. It didn't start till spring of 2022, months after he was hired, and I gave back cash, and then I got sitting on stacks of cash, and I don't have money to pay my bills, but I'm sitting on stacks of cash, and here's someone who once saw Fani holding a wad of cash, so now you know it's true. It's like they sound so pathetic, so pathetic. That's why they're facing so much scrutiny from this court. If they just would have come out and said, yeah, we were dating for 3 years. We were. But that had nothing to do with prosecuting Trump or any of these co-defendants or Michael Roman or any of these other people. That would have been far more compelling here. You might have lost Wade. But Fani Willis would certainly still be here. But she had too much arrogance to admit that she had been busted. Too much arrogance to admit that she'd been busted. Because I'll tell you right now, if she had come forward with that right away, I feel very confident that this judge would keep it at, all right, let's get rid of Wade, and then there's no taint at all. She's coming forward and telling us about the relationship, the amount of money she got from this. Come on, what are you talking about here? A few $1,000s over the course of several years? I mean, come on. That's not like something that I'm going to basically say that was her primary motivation here. That's what they should have said. That's just someone who would have slapped her across the face saying, take it on the chin. I'm sure you've taken it on the chin many times before, Fanny. Take this one on the chin too. Move forward. But she couldn't. She couldn't. She's too small a human being. That's one of the few ways she is full. She is small. Fani Willis has already been disqualified when she tried to prosecute Georgia's lieutenant governor. She's a clear and present danger to the United States. In a lot of ways. Abbate is an unethical piece of crap, and I still feel sorry he had to argue this crap position. Okay, no, I don't. I don't feel the slightest bit sorry for him. Bradley's text said Wade and Fanny are arrogant, and you see it when they both understand. That's what they have the attitude that they do. Yep, and that's why, and that's part of the reason everyone's enjoying this. That's part of the reason I got 2,300 people watching me. I got 3,000 people watching me live right now. That's why. That's why. S-Dasp says, I'm curious what the contract price was offered to the former governor. I guarantee it was way less than Wade. Even at $250 an hour. To most attorneys who actually have a paying job, that's a joke. That's a joke. He's like, I could be making $1 million or I could be making $250,000 from you. Why the hell would I possibly sign up for this? And alienate half the state against me in the process. No, thank you. It's really that simple. I'm sure the conversation was, they might not have even gotten to what role he would be, whether he'd be lead or not, if he had been asked about it, because he would just be like, I seriously can make over $1 million a year doing what I'm doing. Why the hell would I cap myself at 250 and then face scrutiny from the entire country? I don't need the publicity. I got plenty of publicity. I got no upside here. I just got plenty of downside. So there was no reason for him to take the case. It was stupid to ask him in the first place. And perhaps you can argue that he likely thought that they knew that he would say no because he'd have to be an idiot to say yes, and he's certainly not an idiot. Oh, I knew what I was saying.
Have information as it relates to specifically, for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified.
Okay.
That's telling. Because if
telling.
it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture.
It was true, though.
Those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley.
The judge already told you it's not just speculation. He told you that 30 minutes ago, that it's not just speculation. They admitted it. You're trying to sit here, come back to your whole speculation thing.
You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Ms. Willis did, in fact, pay in cash up to more than $400. And I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statement's credibility and credence before the court. You heard about...
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
Oh, you want us to bring in... You want me to start listening to you about the whole Napa Valley thing? Oh, I'm going to take him in. I got to take in the phone records. You want to make that trade, Abbate? You want to make that trade? I'm sure the defense would be happy to take that affidavit and testimony of some stupid idiot who says, hey, one time I saw that Fani Willis actually had more than $30 of cash in her pocket. because that's very compelling. And at the same time, I'll also be taking in here these phone records, which basically show that your dude was making late night trips into Fanny in many months before he was hired, before you admit that there was a relationship here. Multiple trips. One trip was in September before he was hired, another November which was many months before there was a supposed relationship that he's coming for and staying overnight. Well, we'll take both of those in. You want to make that trade of body? He's about to try and claim why it is that the phone records are totally unreliable. Totally unreliable.
I have, I'll get to that now.
Let me cross my arms here and get defensive here as to like how much I hate those phone records.
We'll get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them routinely, but we use them with an expert. And they're always challenged.
That's not true.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about them.
No. Focusing on the substance, I'm assuming that it would be admissible in the guise that he's proffered. Maybe you have that further up, but what's the reaction to that?
So what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert,
in the reply, Sado points out, and these are foundational concerns, which is exactly what the judge says I don't want to hear about. But he's like, what about the idea as far as just admitting them in general, ignoring foundational? He's like, well, let me go back and talk about the foundational issues as to why you shouldn't rely on him, because there's not enough foundation because he's not an expert. So I'll just ignore it the way you want me to phrase it and try to phrase it the way I want to, because I don't have any other argument here. So let me try and scrape at the one argument I think I do have. He's also ignoring this foundational argument where he's like, since it's not an expert, the state only brings in with an expert. That's not true. And Sado pointed that out in his reply, that many times they don't have an expert and they bring it in and criminal trial after criminal trial. You don't have to have an expert here. And the judge doesn't seem very concerned about it, because if he was concerned about it, he would be asking him for the foundational stuff. So it seems like the judge isn't really that worried about the foundational stuff. He'd be like, lay out for me all the foundational problems here. But he's not saying that. And the reason he's telling him to move past that is because the judge presumably is already past the foundational issues. And yet here's Adam Abbate doing his very best lawyering, going back into foundational issues. Go get him, Adam. This is a sure winner here.
Analyzation of those cell phone records were not properly peer reviewed. They were not, it's clear from the state's review that the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates. I believe it's September 10th and 11th and November 29th and 30th. The affidavit that is used to say that Mr. Wade remains at Ms. Willis's or in the area of Hateville, because again, during the hearing, the address for the Yurdi condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And
Sado cut the legs out of the argument that he's making now. What he's essentially arguing is, here's why you should ignore this is less of foundational, and this is more as far as the probative value of these of the phone records. The phone records basically don't identify an address that he was in at 4:00 in the morning. They just show he was in Hateville. The problem is that Sado anticipated this when he had Wade on the stand. And he basically said to Wade, give me all the places that you would be visiting in Hateville. If he was intelligent and had actually thought things through as to how to try to fix this mistake of his, he would have come up with, well, I got friends in the area there. I got multiple friends in the area there. He probably would have pressed on who, but this way, you'd say some of them are personal, private relationships with various people besides Fani Willis. I'd like to maintain their confidence, and the judge likely would have respected that. But if he would have implied that he's got all sorts of girlfriends that he visits there, in that case, these phone records would be kind of useless, right? But he didn't foresee that. Even when questioned as to, if I have phone records that show that you were in Hateville at odd times, they would be lying, and he stupidly said, yes, they would be. My phone must have been stolen and returned to me. Stolen at midnight and returned to me at 5:30 in the morning. What an idiot. What an idiot. He's so stupid. What a stupid man. He's such a stupid man. But he could have just left himself such an easy out there. Such an easy out. Instead, he's like, Porsche Experience. Yeah, Porsche Experience closes at 5 p.m. Delta headquarters. I go to Delta headquarters all the time. It's in the Hapeville region. Oh my God. It's like, it's such morons. Utter morons. You're just morons. So bad at this. You're happy to perjure yourself. Do it well. Jeez. Unbelievable.
The documents that were provided to the state that were certified business records did not have a subscriber page. So we have no idea that
Foundational
the number belongs
question.
to Mr. Wade. Now, I
That's a foundational question.
understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that. But if somewhere, how they were able to survive those foundational concerns.
That means I don't think there are foundational issues here. I don't think there are serious foundational issues. So if if you bring yourself where I am, that I'm no longer thinking about foundational issues, what arguments do you have left as to why I should not admit these records?
Do you have any reaction?
Yes, I do, and I will skip forward so I don't. So what's interesting is that the records that were provided they start in January of 2021 and they go, I believe it's to November 30th, I think is what of 2021, the span of the records. And you heard from all of the witnesses, including Ms. Yurdy, that Ms. Willis did not move into the Hapeville address until April of 2021. That was...
Yeah, but the geolocation puts him in September of 2021 when she was living in Hapeville.
The testimony from all of the witnesses.
And in
April
November of
2021. And that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So
35 times. 35 times. What are you talking about? What are you talking about? 35 times. And she admitted that no one else ever visited her in Hapeville. Nobody even knew she was there other than Wade. 35 times. God, so bad.
a year and a half or so, but he never once enters the area of her home.
35
they
times.
Want you to believe that that's a lie, which is why.
Never once. 35 times. They admitted to 10 times. 35 times. Oh my God.
Counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home. And
no one said she did. They went to the home.
If you've been in a relationship, as they claim, for all this time, but never once.
No, she's keeping it secret from her dad. That's what everyone's been saying. She's been keeping it secret from her dad. Dad's like, I didn't meet the guy. I don't even know who the dude is. I don't know the dude who's doing my daughter. I didn't meet Deuce either. Remember Deuce? I don't know Deuce either. I don't know anyone. I don't know who she's with. Her dad's like, you think I keep track of that hoe? I can't keep track of her. It was a lonely, lonely time.
Never once went to the house. So I think that's telling. What I would also bring to the court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live, again, at the Hapeville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How do you reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
would those line up to 23 times? I think,
well,
he didn't give too many reasons for being there, right?
Well, I think that's the point.
Look at her.
I would say yes, that is the point. he referenced that that's an area that it was not uncommon for him to be in. And clearly that is the case because Ms. Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And after Ms. Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote.
Which head? Look at them looking so bitter, all of them, looking so bitter. They smell it. They smell the rancid meat. They're smelling it.
At that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that
not uncommon, but also not necessary. That's the problem you have. So that's why there's no foundational issues here, because you guys rely on having non-expert testimony about phone records in criminal trial after criminal trial. And now you're like, no, you need experts here. No, that's not your position in case after case after case. So that's kind of a problem you got there. Anna P., you are late. You missed so much good stuff. So much good stuff. So sorry, not a cult leader. It's not a cult, and I'm not a leader. So I don't even know who you're talking to. But I assume you're talking to me because you figure I'm going to read it. So yeah, I certainly forgive you. But it's not a cult, and I'm not a leader. It's not at all a cult type of cult. You should give the what the hell's court here. You should grift the what the hell's court hearing. I might do that. This week. I don't know enough about it. I saw that DUI guy was trying to cover it. I'm thinking about jumping in on that. As I mentioned earlier, I'm going to be throwing out on my locals, which is free. This will be nothing here will cost anyone a penny. Okay. If you sign up at goodlawgic.locals.com, you don't need to become a paying member. You get notifications about where I am. I'm very, very close to signing a deal with people where I'd be basically doing live streaming during the day and for several hours at a time. So and that's going to be on a different platform, not Rumble, not YouTube. It'll be exclusive over in a different social media place that I'll provide links to and notifications about at goodlawgic.locals.com. And this is likely going to start within the next day or two. So I'm urging you to sign up at Good Lawgic so you can keep track of that. And that probably is where I would go with Hales. If I go there, I probably will start jumping on the whole Hales, what the Hales thing. So, yeah. And can we talk about how Fani left the courtroom before we go back to his seat? Sorry, I drink it too. So I'm jumping ahead, but I found it funny and telling. Oh, we're getting there. She's almost about to pop out soon. It's only 20 minutes left, and that's including 5 minutes. So she's gonna leave in the next 15 minutes or so. So we're almost there. We are almost there.
Actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that
no. It's a newer platform, but it's a new platform. But no, it's only out a few months. So, but I'll provide links, and signing up there is free. That's the other thing I should mention. You're not going to have to pay any money to watch me over there. Getting notifications from me about it will be free. Watching me there will be 100% free. It won't cost you a penny. It's a matter of helping broaden their reach. So it's not going to cost you anything. And if anything, it might be more, I might be able to have more expansive stuff where I can actually bring people up on stage, which is kind of cool. Are you going to be a legal analyst on CNN that calls for goat sacrifice? Definitely not. No Kool-Aid, no goat sacrifices, no CNN. Definitely not. No.
you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention as it relates to the validity of the app.
When I live streamed it, I had that view. I wanted this view to be able to break down his hand motions better and stuff like that. I used that same Zoom feed from McAfee's own YouTube channel. You can watch my coverage of it in real time on Friday if you want to. I wanted this view for whatever. And no, it's not Rumble. It's a brand new platform.
Affidavit and the analysis done by the expert that was hired by Mr.
You'll
Sadov
probably hear about it in the next 48 hours.
Not once does it reference the fact that AT&T records commonly have duplicate and triplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you are close with, and the number of times that you make calls to any of those people. I can submit to the court that I have a friend who I've been friends with for 15 years, and she worked in the office previously with me. And based on our professional relationship and our personal relationship, the friendship that we had and still have, that we talk 30 times a day. So doesn't mean we're in a relationship.
Seriously.
So the assertion that the number of times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship.
No validity at all. 12,000 text messages, 2,000 phone calls. In 11 months. No validity. Okay. All right.
What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional
very expensive burner phones, cell phone costs, text messaging costs, very severe costs.
Expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety in her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since
my
all of these
God.
instances occurred.
The world's smallest
The
violin playing here.
full nature of the statements and the falsehoods that, for example, in these text messages that were purposely leaked to the media as it relates to Ms. Willis's daughter,
He did.
subjecting her
He did.
position in school, that she flunked out of college, which isn't true, which in fact she has graduated from an HBCU. But
This is like so obviously written by Fani. My daughter graduated from an HBCU.
what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while,
No, you got a Napa Valley guy saying he was in California then, so I don't know. The timing kind of adds up there.
Miss Willis facing these costs has been able to
You got plane tickets showing they went to Napa, so yeah, I think that it pretty much was shown.
continue to do the work unrelated to this case, which is shown in the
Maybe this is it. Maybe it's that they're so used to successfully gaslighting that this dude thinks he can gaslight this judge as to what evidence was presented at this trial or was not presented, and that he's like, oh, the judge is totally going to buy this. I agree with you all. I don't think he wrote this. I think Abbate is actually more intelligent than this, and that this is a sign of lunacy, of hubris. That if I tell the judge what was presented in evidence, he'll just believe me. And now he's forced to read he's forced to read someone else's homework here. And I'm glad he's facing this humiliation because he was such a dick throughout the hearing. Frankly, that's why his heart doesn't seem like it's into it. I agree with that read as well. It makes sense.
the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from.
A little note passed up there by assistant note passer saying, Fani says you suck.
The relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit.
Miss Wade. He called her Miss Wade. Let's go back. That's funny. I think he's being corrected. Maybe that's what he's being corrected about. How many times did he say Miss Wade?
Was never shown. And all the while, Ms. Willis facing these costs has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office.
Uh-huh. Tell us more about Miss Wade.
What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from
Wade.
the relationship between
her. This boy is so spun in knots.
her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of it.
No, instead he's gaslighting that it has to do with this case. That's what he's saying right now. Unbelievable. No, I'm gonna still be doing here in the evenings. I'll still be doing here in the evenings. When I'm doing that other thing, I'll still be doing this as well.
The case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which Had she gone with all 39, there, based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain, as alleged, from the prosecution of this case?
It's the uhs and ums that make it so painful to listen to. The uhs and ums. But yeah, this is so many ways. This is just disaster. This is a Hindenburg going on right here. That's what we're saying. Oh my God. Oh, the humanity. Oh, the humanity. Yeah, there's a lot lower crime rate when you're not charging anyone.
It doesn't line up. It doesn't make sense. And
doesn't
it doesn't make sense for a reason.
Let's go back to it doesn't make sense. Why would a Wookiee live on Endor? It doesn't make sense.
This office has multiple RICO and as well as large scale cases like this one and much larger. And they also there's a lot of high profile prosecutions. If Miss Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa.
Norwegian cruise that she admitted to? No? Okay.
They want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke, an absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what has to be shown is that the statements that were made by Miss Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. We have none of those statements. There's been no evidence. Nothing has been provided to your honor as it relates to Ms. Willis' specific statements made about any of the defendants and in relation.
I think we're well past the point where this dog needs a bullet to the brain. And God forbid, just so that YouTube isn't confused by what I just said here. I don't mean literally, but I'm simply saying like this, just like mercy, just mercy at this point. Oh my God. Just someone show some kindness.
To the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate in the previous year that she was serving as a district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Ms. Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Ms. Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them.
We're about to hear it on Thursday. Again, Thursday is the Ethics Committee hearing. I will be live streaming it right here, not on any other channel. I'll be live streaming that here. I'm going to be live streaming that for sure. I'm going to be live streaming that. So, yeah, You'll find that also on goodlogic.locals.com. That's supposed to be Thursday at 10 in the morning. And I'm expecting it's going to be live stream. Yeah, 95% conviction rate. She tries like 4 cases. Everything else is about this case. But, you know, in those 4 cases, 95% of them.
This is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis. And it involved a statement that the words fake electors were said by Ms. Willis. And he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct. And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to the speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding to comments made by Marjorie Taylor Greene and Bridget Thorne, 2 other political.
She just happened to bring that up like 5 days after this motion became national story. Happened to. Oh, totally about Marjorie Taylor Greene.
Officials, therefore making her comments not even close in the realm of any sort of forensic misconduct.
Not even close in the realm. I guess what he's implying here is that if in fact it was established that she really was talking about this case, in that case that he's recognizing that would be forensic misconduct. Okay, that's what I take from it.
Interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in her defense as 2 unrelated, in this case, public officials criticized the job that she was doing. And I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel.
They're allowed to do that.
In relation to this case, we had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his.
Is that a rug? I didn't notice it until just now. I think he's wearing a rug. That's totally a rug, isn't it? Look at the different shading on the top here. That's a really good rug. That's totally a rug. It's weird because his hair in front looks really good. That looks like a rug to me. You can even see the whole outline here. Dang. Dang, boy. That's totally a piece.
Private and personal information, causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made.
Anna, I know you said you've been drinking, but I literally said 3 minutes ago. Yes, I will be live streaming it. It starts Thursday, March 7th at 10 a.m. You'll see notifications about it in locals, goodlogic.locals.com, goodlogic.locals.com. March 7th, 10 a.m. I will be streaming it. If it's anywhere on the internet, I will be streaming it. And I'm fairly certain it will be. I'll be shocked if it's not.
Made clear.
Only because I've seen, the reason I'll be shocked if it's not is because I've seen others of the Georgia Commission hearings that end up on social media. So I feel like they, as a habit, tend to share their work. So I'm confident that it will be publicly available, and I definitely plan on watching that. Whether it goes for an hour or whether it goes for a month and a half, which I don't know which way it's going to go. Probably somewhere in between there. Hopefully closer to the latter, because oh my God, if it goes closer to the latter, I will hit 100K this month.
Hearings that the ability to get those the full chain was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selected prosecution for political benefit or gain. All allegations that have been made in the course of different hearings and the procedures as it relates to this case. What I would leave the court with, and how the state started the argument, is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, the standard is very, very high that must be met in order for an elected district attorney.
We have it here in spades.
And that burden, that standard has not been met. An actual conflict has not been shown. And
so in case some of you missed it, the ethics hearing will be March 7th at 10 a.m. this Thursday, 10 a.m. March 7th, 10 a.m. All right, this Thursday. I will be live streaming it right here on YouTube, right here on Rumble, right here on X. All right, that's going to be here. I'm going to be live streaming it here, starting Thursday, 10 a.m. I know you're trolling. When you hit 100K, I'll donate $2 to the chat. Oh, that's so kind of you. Thank you. Thank you very, very much. That's the reason I'm trying to get to 100K, is just to get you $2. That's the real motive. Now I'm motivated. Now I'm motivated.
More importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we would respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
Out of there. I am out of here. I am out of here. Where's my security?
Mr. Cromwell. Oh, you, okay, handing it over. Understood. Mr. Sadow, all yours.
There you go. There you go.
I'm going to do rebuttal, specific rebuttal. One, state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. And Wade's counsel objected over and over and over, claiming that everything
I'm just totally nodding at this.
Bradley was told by Wade was attorney-client privilege.
Yeah, I know.
Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take. It's disingenuous as it can be. Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand.
We'll be ecstatic.
As the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done. Second.
Yep.
Let's use a little common sense here. Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty.
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct. Why is that?
I'm sorry, say
Thanks
that.
here. Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. I think that I guess the state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man. They're not talking about Miss Thorne or Marjorie Taylor Greene.
Because Marjorie Taylor Greene didn't fixate on Nathan Wade. She didn't fixate on Nathan Wade. So when they talk about the black man, that's talking about this motion attacking Wade.
They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist. They're racist.
Which is a terrible, terrible, terrible act of misconduct. Because what you're trying to do is you're trying to obtain convictions based on allegations that have nothing to do with the crime and just by impugning the character of the defendants. And that's essentially what she's doing. That's what she's doing. She's poisoning a potential jury pool. And that is forensic misconduct. That is a terrible, terrible violation. It's a very clear violation. And this is why the dude was an idiot for bringing this up. He never should have brought up the Abbate never should have brought up the church speech, because he's walking into something saying, they didn't call out any of these people by name. They called out Marjorie Taylor Greene. It was about them. No, she talked about the black man and they're attacking the black man and a former judge and whatever. Then this highly good, great attorney, Nathan Wade, brilliant man, brilliant attorney, Nathan Wade, and how they're going after him because he's a black man. And Marjorie Taylor Greene wasn't going after Nathan Wade. No. Only one going after Nathan Wade were these folks. These folks, well, I guess from your perspective, these folks right here, well, whatever. These folks right here were the ones going after Nathan Wade. It was clear to everyone, based on the timing, based on the choice of how she brought her attack. It was definitely an attack based on racism, and it was an attack against the defendants and or their counsel. So, yeah, and that is forensic misconduct. Please excuse my degenerate self. It's my bad. I've been behind. Jump forwards. I missed it. Definitely wasn't the drinks. Don't worry about it, Anna. You're awesome. Don't worry about it. I thought it was funny. Because I literally said it like 3 minutes earlier. So I was like, how's this happening? How can anyone not know yet?
They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem.
Yep.
Obviously, that makes no sense whatsoever.
Yep.
The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade and Willis in this case. Let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis.
They're the ones who said that.
No soul was ever told that they were dating or that there was an intimate relationship, ever. They concealed it from all parties, from Daddy. Daddy didn't even know they had a relationship. Suggest that
He's so good at this. He's such a good attorney. He's a really good attorney. Somehow, in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one
No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yearty. Yearty was best friend at that time of Miss Willis, and Bradley was the partner of Wade.
Yep.
Now,
Killing it. Killing it. Look at the contrast.
the only way that Wade
Look at the
can walk-
contrast.
sorry,
And
the
you can see the conviction with which he says it, because he knows that he's killing them. And the reason Abbate sounds so wimpy, like he's like basically the title character in Diary of a Wimpy Kid, is because he doesn't believe in anything he was saying, because he knew it sounded stupid. They were stupid arguments.
The only way that Bradley can walk away from the at very little time. So I'll skip that. Let's go to something. Motive. That's it. An issue. Whose motive in this case is the strongest? Fani Willis.
By the way, even that, him recognizing that, okay, I have to cut for time. That is just, it's a quick sign that he's standing there actually thinking like an attorney. And like, he's like, I have to be strategic here with my time. I have a point I really wanted to make, but it's not as important as this other point that I need to get to here. And even that is a reflection of a guy who knows what he's doing.
The only way that Bradley can walk away from the at very little time. So I'll skip that. Let's go to something. Motive. That's it. An issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified. Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do.
Yep.
Who wants to stay on this case for whatever the financial reason may be? They do. And
All right. Thank you, Mr. Sato.
He didn't get to. I'll tell you something. He finished strong. He wasn't able to finish as strong as he wanted to due to limitations of time. But you can see even in 5 minutes of this guy talking how much stronger. Just it's like two different professions almost. Like you compare him to Abbate. I'll tell you right now. I'm going to go on a limb. It's going to sound crazy. I'm positive Wade is gone. I'll be shocked if Wade is not gone. I am positive he is gone. Gun to my head right now, I think Fani Willis is gone. I think she's gone. He might try to keep the office in. I don't know how the Georgia law stacks up with respect to a district attorney being removed, what he needs to get to in order to allow her office to stay. But I'll tell you right now, I gun to my head, I think she's gone. And not enough bad things can happen to her from a political and career perspective than I am. She should become a short order cook. That's what she needs to become. She's a terrible person, bad attorney, terrible person, and just so vindictive. Such a nasty little piece of work she is. That I'd love to see her career come to a crashing end. Because that woman, she's not a nice person. Not a nice person at all. And she doesn't care about justice. Forget about being nice. You don't have to be nice to be good at your job as district attorney. But she doesn't care about justice. She cares about herself. I think she's a racist. I think she's terrible. I think she's a terrible human being. Anyway, and I think that most of you tend to agree with me, which is why so many people are so fascinated by this case, because they're really enjoying watching her come up and come. And you'll be able to see more of that if you tune in, goodlogic.locals.com, and you'll follow me on Rumble and YouTube, where I will give you notifications as to this hearing, which is supposed to be happening this coming Thursday, March 7th at 10 a.m. I will be live streaming this hearing, and I expect you all to come back here and join me, because that is going to be something to see. And I think potentially we might see even greater evidence of all of the illicit wrongs she's committed, far beyond her romantic entanglements with Wade, far beyond, with respect to her financial reporting, with respect to her crazy appearances that she makes. We're gonna be seeing a lot more information come out about Fani Wade. I'm hoping, assuming that they don't just do a little slap on the wrist, but they actually engage in a real investigation of the complaints that have been alleged against her. It should be glorious. And that will all start Thursday at 10 a.m. Please, wherever you are, make sure you hit like, make sure you hit subscribe. You can drop a comment down below. That really, really helps the algorithm, and it just makes my heart fill with makes my heart sing. I say. So if you can help me out with that way, I would appreciate it. I'm going to be landing my plane here. I thank you all for joining me. I will be back tomorrow evening. Till then, take care of yourselves. goodlawgik.locals.com. Stay happy. Eat the bugs. And as always, my friends, I say to you, thank you for joining me. And Godspeed.